This case opens with a fight over credibility long before any ruling is made. One side is trying to frame financial hardship as a legitimate obstacle, while the other side is preparing to challenge the entire foundation of that claim.
Ms. Vanderkachove is a fraud. She is collecting Medicaid for the minor children when those kids are covered under my client's health insurance. Good morning, Elliot Blumberg on behalf of Nicholas Vanderkachove, who's appearing via Zoom from my office.
All right. We have a few different matters. There was a show cause. We also needed to address the calculation and the recommendation, and then there's also a motion, I believe, to change child support. Is that correct, Ms. Richards?
Yes, Your Honor.
All right. What do you want to say regarding the status of this matter?
Well, as you've established, there's a lot going on. For the show cause, Ms. Vanderkachove has been in contact with friend of the court to attempt to set up a payment plan. However, as indicated in the motion, Ms. Vanderkachove is currently unable to work due to a medical condition. She has an appointment with a specialist coming up this summer. Currently, she's not able, her primary care physician is unable to diagnose her with anything that is outside the scope of her practice, hence the referral to the specialist. So we would ask that her payments be set to zero. In the recent recommendation, friend of the court indicated that there is a medical needs verification form. Ms. Vanderkachove has obtained that form and has given it to her provider. She just hasn't received that back yet. And with regards to the most recent recommendation for child support, the child care costs have not changed. At the bench trial before Judge Mertz last fall, we agreed that the child support would be recalculated based on Mr. Vanderkachove's new job. It's our understanding that job he has shifted to day shift, so his child care should be for one child during the day. We do not believe that the child care costs listed are accurate, and further, the child care costs are over 50% of Ms. Vanderkachove's base support amount, so we would ask that it be lowered based on both that we do not believe the child care costs are accurate, especially compared to other child care costs in the area for one child, and the amount of the support.
When did your client stop working, the best that you know?
She has not been working. During the relationship, she was a stay-at-home mother. After leaving the relationship, she did try to find a job, but had issues with that. And then the disability has been ongoing, but it was only after the birth of her youngest child that it became so severe that she couldn't work. So it has been a while since she has had a job. She's not had a job through the duration of this proceeding.
Thank you. Mr. Blumberg, what would you like to say?
Judge, I will try to be tactful. Ms. Vanderkachove is a fraud. She is collecting Medicaid for the minor children when those kids are covered under my client's health insurance that he's paying for every month. She can work. The documentation she presented to the court was signed by a nurse practitioner, not even a medical doctor. We believe she simply doesn't want to work. She can work. She's receiving $2,000 a month in food stamps that she's probably not entitled to. I don't think the relief that's being requested is appropriate, absent some real accurate and professional documentation. She simply has an arrears of about $13,000 that she doesn't want to pay. And I think the court should simply deny the request that she's asking for.
Thank you. So, Ms. Richards, are you asking for an opportunity to have an evidentiary hearing to provide additional evidence and proof that your client is incapacitated?
Yes, Your Honor. I don't know if you would like to schedule an evidentiary hearing or just adjourn out a pretrial. We would like to have it after her appointment with the specialist. I believe the date is included in the motion. That specialist is with a medical doctor. As I'm sure we're all aware, nurse practitioners can be as primary care physicians. It is hard to get an appointment with a medical doctor. So that's what that appointment is. I also understand that it is hard to get a diagnosis for a disability. So it may take longer than just one appointment with the specialist pain clinic in Traverse City to get a diagnosis.
Okay. Well, I think certainly a hearing would be appropriate to see if that burden can be met, to establish that she's incapacitated at some point to address the support. Obviously, I've got concerns that a support order went into well, there was a support order with a lot of back support now that we're at. I don't know what her plan is to get that paid and make payments on that. She's not currently working, but that doesn't potentially go away. Future support can be addressed, but back in time is going to be a much different issue. So it's going to be on her to get some payments in, or at this time, I'm not going to agree to some type of payment plan, but it always puts her, every dollar that she pays puts her in a better light when it comes to dealing with the show causes.
The judge's response reveals a practical mindset rather than an emotional one. Instead of accepting or rejecting either story, the court focuses on proof. That is often a sign that the judge sees unanswered questions on both sides.
And then we can address the other support issues as well. Are the parties available July 22nd at 1 o'clock?
Let me just take a look, please. I am the first day of a 3-day trial starting the 21st.
How about July 29th at 1 o'clock?
Right now, I am absolutely wide open.
July 29th at 1 o'clock also works for me.
All right, so we'll set these matters for July 29th at 1 p.m. And as stated, your client shouldn't be waiting around for some type of court-ordered payment plan. She should be making whatever payments she can, and we'll readdress the show cause as well on that date.
And will that also address the recommendation that was scheduled for today?
Yes.
Okay. And will that be a full or an evidentiary hearing?
Yes.
And like I said, it's getting a diagnosis is hard. If there is an issue with the doctor where they need more testing or more follow-up appointments, would you like me to let the court know and potentially adjourn that, or just continue with the evidentiary hearing with the evidence we have on that day?
Yeah, I'd like to get as much in as we can. If there is some need to get some additional document, we can address that.
Okay.
But this thing's been lingering a bit, and there's money at stake, so I think it's appropriate to at least, we'll begin that day. If there's some other additional piece of evidence, we can address an additional date to deal with that. Perfect.
And how long is that hearing scheduled for?
I'm giving you the afternoon if you need it, so you got 3 hours. If you do need to file any witness and exhibit list 21 days prior. Mr. Blumberg, anything additional today?
I don't believe so.
Thank you. Ms. Richards, anything additional?
No, thank you, Your Honor.
All right, thank you both for appearing. We'll see you back here on this matter July 29th. Speak right up if you're here and can hear me.
Yes, I can hear you, sir. Where I live, it's a little bit choppy, so I do apologize if I cut in and out.
Okay.
Was that pretty clear?
That was good, yes.
Okay, thank you so much.
Ms. Mullen, can you hear me okay?
Yes, sir.
All right, looks like we're here today on a parenting time complaint against Ms. Mullen, filed by Mr. Minkevich. So, sir, how are you saying the order was violated?
So the order was violated. I contacted Olivia to show up at Wolverine where we met, and she did not show up for multiple different dates. And so it's been 56 days since the 1st of April that I've yet to see my kid. And I've contacted her, say, hey, I'll be there. And she says, I'm not coming. So this is the second time I actually filed a complaint. The first time, friend of court did not get the proper documentation from the county clerk. So I had to provide proper documentation to the friend of the court. So I had to restart all this events all over again. So now we're just finally getting into actually the days where I consider that, even though like last week there could have been another violation, and I missed a couple of the holidays also without my kid.
All right, ma'am, what do you want to say?
I had filed an ex parte motion on April 4th, or there was an incident, excuse me, on April 4th. And then I had filed an ex parte motion. I guess between the mail taking, I don't know, over a week back and forth, these orders had come in between that. So my ex parte was denied because this hearing was already in play. But so I guess that's why we're here. I'm not sure.
Well, it looks like your ex parte was denied due to insufficient evidence of irreparable harm to meet the ex parte relief standard, and then it was referred to the friend court for this hearing. So is there a court order saying he is supposed to have parenting time?
Yes.
And are you withholding his parenting time?
Only for this reason. We had an altercation at pickup.
Okay.
So my concern is for Kai's safety, and I'm just
altercation
trying
between you and him? Was the altercation between him and the child? What did it do to put the child at harm?
It was between him, the child, and I.
Okay.
My explanation of the incident is in a letter that I sent with the ex parte of the incident.
A major weakness begins to emerge in the mother's position. Despite expressing concerns, she acknowledges that she is withholding parenting time while simultaneously seeking court approval after the fact.
So you think his parenting time should be suspended completely, or what is it that you think should happen?
No, I'm just asking that maybe we can get some kind of suggestion to do some anger management and some parenting classes to see if, that way maybe help. I think this is just personal things going on. I truly don't believe that Tyler wants to hurt either of us. I think that this is just an underlying emotional issue that we can definitely take care of. So I'm not trying to really take it away. I just want to know that he is doing things to get better and be able to control his emotions in a situation when things aren't going his way. We're only here right now anyway because he assaulted me, and I filed, we had a divorce, and this is why we're here in the first place. So really just asking that the court supports that Tyler needs to have some kind of classes or support in that way so that he can be the best dad for Kai. Right now, I just want to have that support.
How long has this parenting time been happening?
This situation occurred on April 1st, and Kai has not seen him in person since then. Tyler asked for a video chat one time, and we did that.
So at one point, his parenting time was suspended, and then it started back up. Is that correct?
Correct. There's a previous CPS.
When did it start back?
According to the paperwork, I believe in December of 24.
Okay, so he had parenting time throughout 2025 and then into 2026, correct?
Correct. We followed the order.
All right. And then you're saying there was an incident on April 1st, and that's why you have stopped parenting time?
Correct. Or the 4th, I think it was. Sorry.
And so you're not going to follow the court order and are asking that there be a court hearing to decide if any changes should be made?
Correct.
Sir, when did you start missing parenting time? Because was it in March or was it in April?
What was that, sir?
When did you start missing your parenting time?
I filed, so Olivia asked me to come early to pick up my kid, which I was 100%
All right, so both
okay.
of you, when I ask a question, hold on. When I ask a question, just answer the question and not give me a bunch of background and fluff and story time.
Sorry.
When did your parenting time stop?
April 1st.
When was your last? Okay. And then, ma'am, I guess I'm trying to understand why his parenting time should not be happening now.
Because of his aggressive behavior.
On the occasion of April 1st.
Correct. There's been multiple incidents with his aggressive behavior. This is just the first time.
Or police involved or CPS? Who got involved due to his aggressive behavior?
I called the police and made a report, and I filed a report with CPS. I have not heard back from CPS yet.
Right. Sir, have you been interviewed by the police or CPS?
No, I have not.
Okay. What do you want to say about this incident, sir, that took place in April?
Well, there's two stories. I mean, there's two sides of every story, Your Honor.
There's a lot more than that.
There was an altercation, but it's what she has reported here is kind of altered by far. So I don't want to make a whole story, but there's definitely documentation here that's not truth. I always also had my girlfriend and her kid there. If it's necessary, I can have them also provide what happened. So Kai was in my possession, and she literally ripped open the door while we were in drive to get him out because he was freaking out about an apple. That was the altercation. This whole story that she made up here is not the truth.
All right. So the next available court date that I have is not until July 22nd. Her motion, let me take another look at her motion.
The father's defense relies heavily on competing narratives rather than documented findings. He challenges the mother's version of events and suggests key details have been exaggerated. While that may help create doubt, it does not automatically solve his problem.
So, ma'am, your request is that what? He does some type of counseling before parenting time resumes?
Yes.
So, other than that April incident, you've been having parenting time for a year and 4 months or so. Were there issues going on during his parenting time at that time?
Kai's behavior definitely was altered. He was more aggressive, not listening, hitting. We even had some issues at daycare with his aggressive behavior, and this was consistent with when he would come home from his dad's. And I lived in that home for several years, so I'm definitely privy to the way that things go there and how things are handled, and that concerns me. So that's why I suggest that the parenting classes and definitely some type of anger management, because as parents, our first response to our child not listening, it cannot be.
Ma'am, hold on. We went a little beyond my question and kind of danced around it mostly, but all right. So I'm going to give you guys a hearing date on July 22nd at 1 p.m. to address two things: the show cause against Ms. Mullen and then Ms. Mullen's motion to make changes to the parenting time. Obviously, the prior order is still what remains in effect. If parenting time is withheld, continues to be withheld, and there is not good cause to withhold it, and that's certainly a factor when the court looks at the best interest factors, as well as any parenting time that is wrongfully withheld could be made up or would be made up if there's not good cause to withhold that parenting time. Unfortunately, I don't have a earlier court date. The earlier dates in July got filled up earlier today. So July 22nd at 1 p.m. is your hearing time. That is an in-person hearing. You need to file a witness and exhibit list. If you intend to call any witnesses or seek to admit any exhibits, that needs to be filed 21 days prior to the hearing. Hearsay is not admissible, so if you intend to try and get things in from CPS and police, you're going to need to address the ability to have witnesses present. And we'll address then whether or not there should be any changes and whether or not Ms. Mullins should be found in contempt and whether or not there should be make-up parenting time. Any questions, sir?
Yes. Do I get my kid back then?
Well, the court order is the court order still. I don't know what Ms. Mullins would do or not do, but that's what the court order is.
The court order says I can have my kid back then, you're saying, sir.
Understand what the order says.
Okay.
And if
So
parenting time is with plea, then that is the issue the court will address at that hearing, as well as any potential make-up parenting time. Any questions, Ms. Mullins?
Nope.
Sir, you cut out real quick when I was just hearing that. So I don't get my kid back on Sunday when I was supposed to have parenting time?
I did not say that, no. Your
Okay,
court order is what controls at this time.
Okay, so perfect. So if she doesn't show up Sunday when I say I'm in there, it's another violation you're saying then, sir?
If the court order is not followed, either party has the right to file an additional parenting time complaint.
Okay.
And at that hearing in July, I will address all parenting time complaints that have been filed and all new parenting time complaint issues at that date.
Yes, sir. Thank you so much. I appreciate your time.
Any questions, ma'am?
Nope.
All right, thank you. We'll see you both here in person on July 22nd.
Thank you.
The final section reveals the court's larger concern. The judge is protecting the process itself. Rather than deciding major parenting issues based on incomplete information, the court schedules a full evidentiary hearing and places both parties on notice. Witnesses, exhibits, police reports, and CP's involvement must all meet evidentiary standards. That warning matters because many litigants assume allegations carry the same weight as proof. They do not. The father's repeated questions about immediate parenting time expose a growing frustration, but the judge avoids making promises beyond the existing order. By the end, neither side receives the outcome they truly wanted. Instead, the court creates a battlefield where evidence will determine the result. The next hearing is no longer about accusations. It is about who can actually prove them.